just from our side, my lady, I want to request, and hopefully my colleague will agree, is that the one condition that is in respect of Mr. Jordan, the one that requires him to report his travel arrangements, that condition be relaxed. He has committed himself to do it. He's done it several times. He remains a special advisor to the president of CAF and to the executive, and sometimes arrangements have to be made at short notice. And I recall personally from a few weeks ago, he was quite panicky because he wasn't able to get hold of my learned friend, the prosecutor, and of my instructing attorney. It was an awkward time of the year, and do I go, don't I go? We don't think there's any prejudice that this condition be relaxed or removed. He has paid his bail and remains on bail, my lady, as the court pleases.
Which condition is it?
This is the condition that requires Mr. Jordan to indicate 72 hours in advance the traveller. It's not for, to be clear, it's not for permission for him to travel. It's just that he must indicate his travel arrangement 72 hours before the time. And as most of soccer people involved in the administration of the game, sometimes these things are arranged at the last minute, and it's not possible to stick to that 72-hour arrangement. But we feel he has complied up to now. He's shown his willingness to do so. He's not going to go anywhere, and it should just be removed in its entirety, Malay, as the court pleases.
Advocate Malebati.
Worship, up until this morning, I wasn't aware that the review application by accused Mike 3. The morning when I checked on my emails, I realized that I had been sent an email which was transmitted at 4 o'clock yesterday afternoon. And unfortunately, at around 5 to 4, I paid my things, and the email was on the dot, 4 o'clock on the dot. So it's about the review application regarding the worship's decision on the last occasion. And based on that, this morning we deliberated and decided we should have a longer remand for this issue to be decided. I believe it will take some time. In the timelines, some of the requested return dates go up to April, if I'm not mistaken, so it will take some time to worship. And again, Mr. Ndebele also sent his request for the review. Advocate Ngwana's decision to dismiss their representations on the last occasion. And unfortunately, there was a correspondence between Mr. Ndebele and the DPP on which I was not copied, but I do not take offense of that. I want to say that I was not aware of the correspondence between the two. But based on their correspondence, Your Worship, it would appear this will take some time. I've had sight of those observations, and they would naturally require the state to respond, verifying some of the allegations and claims therein, which will naturally also necessitate further investigation into those claims. So that on its own will have to take some time before the DPP can make a decision. So I believe the date of the 15th of August 2025 is long enough, and by that recommendation, I believe everything that is on published. So the state has no objection, and this is the method for my next step. As far as the charges 5, 6, and 7 are concerned, it can be true that the state had revised the charge sheet and removed charges 5, 6, and 7 relating to the theft of the 808,000. However, the remaining 4 charges remain: the charges of conspiracy to commit fraud and theft, the charges of fraud and alternative theft remain in respect of the amount of 1,100,000 as well as the 40,250 rand. They still remain in motion. Now, as far as the bail conditions are concerned, the state is objecting to the relaxation of those bail conditions. We've had quite a lengthy address as far as those are concerned during the bail application, and this was kind of struck as a compromise position that the accused number 1 would report 72 hours before departing the worship, as the state was completely opposed to him even departing the country. And the court decided he should make a condition that he reports at least 72 hours. He may be allowed to depart the country, but should report 72 hours before the use of the worship. And it's based on the wisdom of the presiding officer during bail application that this condition is, was made and imposed the worship. And I believe this matter should rather be referred back to the presiding officer who dealt with this issue. But as I say, we believe the condition should remain. And the fact that shadow twice. I, twin, and Asami, is not enough, or rather doesn't improve the need for that condition. That condition has been made for everything as a condition.
Just to deal with that application that is coming through for the amendment of bail condition in respect of accused number 1. I suggest that a proper application be brought before this court. I don't know how the courts that dealt with the bail application arrived to that condition. So a proper application for that condition to be relaxed needs to be brought before court in terms of section 63, because what I'm saying is that the bail application was made under the affidavit was used, which is a form of evidence. But now you're addressing me from the sidebar, and you did not dwell much how did the court arrived to that condition. So this court is not privy to the bail application as to how it was conducted. So basically, I would say that a proper application in a form of affidavit at least be brought before court in terms of section 63 of the Criminal Procedure Act, so that the state also can be given a chance to be able to respond to that application.
As your Lordship pleases, that's why I asked for reason to prevail, and that my colleague will agree to and make it a joint request to you to avoid bringing a formal application, my lady. But,
even for the court.
I think your ladyship's point is that if we must bring a formal application,
Yes.
it must be brought on affidavit or evidence. I accept that.
Thank you. All right, the court, I will state that I have not been served with that review application. I'm also surprised, like the state is indicating, but I'll wait for the service to be done of the review application. But in this court for now, I'm going to request the 3 gentlemen to rise so that I can postpone your matter. Your matter is postponed until the 15th of August, back to court number 9 at 8:30. It is for the outcome of representations. Accused 1 to 3, bail extended with the same conditions, and you are warned back to court number 9, SCCC. I did not note the review. The review is running on its own. I'm running with what is before me. All right, so if we are served, then the review will proceed. But for now, I just make sure that it's postponed, at least in respect of accused number 2 and 4, to know that it's just for the outcome as well of representations. All right, thank you.
As the court pleases, my lady. May we excuse?
Excused.
Thank you.
Excused.